In terms of access to advocates, what would be wrong with a system where consumers had direct access to advocates?
There is a system of direct access to advocates. That system is generally limited to professionals who are seeking opinion work. So, for example, a firm of accountants can instruct an advocate directly for an opinion. A firm of surveyors could instruct an advocate directly. We're in the process of dealing with, for example, the Association of Patent Attorneys. Other bodies of that ilk do have rights of direct access to advocates. Why should there not be general public access directly to advocates? It simply cannot operate on the model that we have. Take, for a simple example, a criminal case. If someone has been charged on indictment, they go to a solicitor. If in due course they need to be represented in court, that solicitor may instruct counsel. If, however, the person who's been charged with an offence goes directly to counsel, counsel is not equipped to make the inquiries, to make the preparation that is always essential for that type of case. They're not in a position to go out and take statements, to liaise with police officers, to do any of these things. That is not our business model, if you like. We simply cannot function in that way. We are a referral bar, but we don't prohibit direct access. In circumstances where, for example, opinion work is sought or similar work is sought, we will accept direct access. And indeed, it goes further than that. For example, we've looked recently at changes of our own regulations to allow direct access for such things as employment tribunal work.
Thank you. Just turning to the issue of solicitor advocates, I realise you don't want to compromise the ongoing consultation, but how could you answer how you feel the current system of solicitor advocates has helped, or has it helped to increase choice and competition of legal services among consumers?
Well, undoubtedly it has. The benefit of a solicitor advocate was always the closer relationship which he might have had with the client, since the client had approached the firm of solicitors in the first place. The solicitor, who might indeed have been a solicitor advocate, although perhaps less so now, the model is now becoming more and more like the faculty, in that solicitor advocates will be operating as such and purely as such within a legal practice. But initially, certainly, there was the opportunity for the client to come directly to someone who would be able to present his or her case in the Supreme Courts, whereas before there had to be the instruction of the solicitor and then the involvement of the specialist pleader to present the case. Now, where the solicitor advocate had the potential advantage was in being the specialist pleader with those skills, but at the same time being in a closer relationship with the client, and therefore perhaps more aware of the client's requirements, rather than being a purely separate professional with a particular role, as the Dean has just described.
Thank you.
Could I just...
Yes, certainly.
Am I allowed to add one point? In theory, it should increase choice. In practice, there are areas of law in which it hasn't, particularly in the area of criminal work. And that's really a regulatory problem. And it's related to a point that Professor Patterson mentioned. You go into a firm of solicitors and explain you've got a particular problem. For example, you've just been charged with murder. And too often, you're offered the solicitor advocate who's the partner of the solicitor you're having the interview with, not the option of going to Queen's Counsel or a member of faculty. Now that is not to decry the system of solicitor advocates. It's just to point out that there is a regulatory issue that needs to be addressed there.
But I think that is, of course, part of the present inquiry following upon the Woodside appeal. Nigel Dawn.
Thank you, Vienna. I'm just wondering, Mr. Keane, if I could just come back to the point that you were previously making about direct access for opinions. Ignore the fact that I'm an MSP, but just I'm an ordinary citizen. I happen to live in a house on an estate where the factor isn't doing a terribly good job. This is a current issue, you may or may not be aware. I recognise, because I have some legal background, that I can see what the issues might be. I don't need a solicitor to tell me what the issues might be, but I really do want counsel's opinion. How would I get that other than going through a solicitor? Or could I get it anyway? I mean, is that one of the...
No, I think you would have to go through a solicitor there. And you see, one of the issues from our perspective is that we don't know that you, Mr. Don, have a law degree. And so we don't know to what extent you're able to analyse the problem and determine that there's what the issue is. And I can say this from personal experience. When you're asked to provide an opinion as counsel, very often you're asked to answer a series of questions. And I have to say, very often you end up redrafting the questions before you give the answers, because it's fundamental to that sort of matter that you know which question to ask. Now, of course, there are people out there who are perfectly able to determine what question to ask and what question they want answered. But we have to decide where, as it were, a line is drawn. And there will be some people above the line who would be able to instruct counsel without going through a solicitor, and some who would not. And it's really just a question of determining where you place what I would call the safety net. And we do it by reference to the background and qualification of those instructing the opinion. The simple ones are accountants, perhaps, but there is a very long list of bodies who can now instruct counsel direct for opinion work, but it's not opened up to the general public because we've got to put the safety net somewhere.
So you've said it's bodies, essentially professional bodies. And that list would appear on your website or something?
Absolutely.
So the public have perfect access to that. It's just that the general public do not have perfect access to you. In fact, they have no access to you. They do have to come through a solicitor if they're coming through as an individual, however well qualified.
That is correct. That is correct.
Okay. If that's the way it is, so be it. That's at least clarified it. Thank you.
Cathy Craigie.
Thank you, Convener. Where are we? Good afternoon. Underlying the Bill's approach to advocates is an assumption that advocates wishing to benefit from practice in business entity involving other advocates, solicitors or a third party, they can do so by becoming solicitors advocates. What costs would be incurred in doing so? And would there be a loss of status for advocates in doing so?
On the former, I think the costs would be absolutely minimal. I mean, we've had instances in the past year where people have left the faculty and become solicitors within a very short period of time. I'm talking about days. So I don't know what the Law Society charges them to go on the role of solicitors, but it wouldn't be difficult. It's one of the interesting aspects of the Scottish bar as distinct from the English bar. As you may know, in England and Wales, the training regime for the bar and solicitors are entirely separate. You might do a law degree, you might not, but they really separate at birth and they never meet again. In Scotland, I think it's fair to say about 95% of advocates have got all the qualifications required to be a solicitor. In fact, the only ones who don't tend to be the people who've come up from England and qualified for the bar up here. Just about everyone else has all the necessary or requisite qualifications to go on the role of solicitors. The issue that I raised in the context of the bill was whether they should have to re-qualify as solicitor advocates, which is just to say, should they become a member of the society or should they be able to practice in the High Court with their previous right of audience. In England, if a barrister becomes a solicitor, he carries with him his right of audience in the Supreme Court or the High Court. That doesn't happen in Scotland, and it's not in the Act. I don't think it's a necessary prerequisite because, in fact, the transfer is fairly simple and fairly straightforward. There is a difference going the other way because, of course, many solicitor advocates become solicitor advocates only for the purposes of criminal work. and therefore if they were going the other way, they would have to address civil qualification.